7 months after the breakup, a letter arrived, formal, professional, and demanding $30,000. She had built her life carefully, her career, her home, her savings, and now the man she had once planned to marry was threatening to take her to court and claim half of everything she had worked for. And here's the part that will make your jaw drop. He might actually have a legal argument. Welcome to one of the most overlooked areas of family law in the United States, and a situation that thousands of people are unknowingly walking into right now. Let's talk about what actually happened here, what the law says, and most importantly, what you need to know to protect yourself. A woman living in Washington State had been with her partner for 7 years. They were engaged for 2 of those years, though there were never any concrete plans to actually walk down the aisle. No venue booked, no date set, just a ring and a label. She was the financially stable one in the relationship. She had a career, a home that she purchased with her own money, a mortgage in her own name. He had dreams of running his own business but struggled to stay financially afloat. She supported him. She believed in him. She wanted to be a good partner. During the relationship, he moved into her home. He contributed what he could, small irregular payments through a money transfer app toward monthly living expenses, payments she often had to chase him down for, payments that came in fragmented pieces because he rarely had enough cash to send it all at once. He also paid to have electricity installed in the garage so he could run his business from her property. That ran about $5,000. Meanwhile, she covered the mortgage, the utilities, the alarm system, the pet bills, the insurance, all of it in her name, all of it from her income. They did some landscaping work together on the property. He swung a shovel, she owned the ground. After 7 years, the relationship ended. She moved forward. She started paying the mortgage entirely on her own. And then, 7 months later, a letter showed up at her door. It was formally written. It cited legal doctrine. It referenced Washington state law specifically. And it demanded $30,000, broken down across several categories. $10,000 for what he called his share of the home's equity, $10,000 for his non-equity mortgage contributions, $5,000 for the garage electrical work, and additional amounts for the landscaping labor he claimed to have provided, which he calculated at 100 hours at $50 an hour. He gave her 1 week to respond before he said he would, quote, proceed with filing. She noted that he conveniently left out the $3,000 he still owed her. She also suspected, with reasonable confidence, that he had used an artificial intelligence tool to draft the letter, given how suddenly polished and legally precise his language had become. Here is where this story takes a turn that many people outside of Washington state would not expect. His legal argument is not entirely made up. In fact, it is grounded in a real and legitimate area of Washington family law. Washington state recognizes what is called a committed intimate relationship. You may also hear it referred to by its older name, a meretricious relationship. The doctrine exists specifically to address long-term cohabiting couples who never legally married. The courts recognized decades ago that people in these relationships often intertwine their finances and lives in ways that can create serious inequities when things fall apart, particularly for the economically weaker partner. Under this doctrine, a Washington court can look at a couple's relationship and, if it meets certain criteria, treat their accumulated assets somewhat similarly to how a divorce court would treat marital property. The factors courts examine include the duration of the relationship, whether the couple lived together continuously, the degree to which they pooled resources or held themselves out to the public as a couple, and the intent of the parties, 7 years together, cohabitation, shared living expenses, a business run out of her home, and engagement. On the surface, several of those boxes get checked. Now, and this is critical, meeting the criteria for a committed intimate relationship does not automatically mean he gets what he's asking for. It doesn't work like a marriage dissolution where assets get divided down the middle. What it does is open the door for a court to examine what would be just and equitable given the specific circumstances. And the specific circumstances here are complicated in ways that likely favor her. The house was purchased entirely with her money before or independent of his contributions. The mortgage is solely in her name. The down payment came entirely from her. His monthly payments to her were framed as contributions toward living expenses, essentially rent, not as equity investments. There are no joint accounts, no shared financial instruments, nothing that clearly signals a mutual intent to build shared wealth. The landscaping claim is particularly thin. He's essentially arguing that his voluntary labor on someone else's property entitles him to compensation at a contracted rate. But there was never a contract. There was never an agreement that his sweat equity would be compensated. Couples do projects together. That is what couples do. Courts are generally not in the business of retroactively billing romantic partners for chores. The garage electrical work is slightly more complicated because there is an actual financial transaction there, money he spent on a permanent improvement to her property. However, it's worth noting that the improvement primarily benefited his own business operations. That context matters. And then there is the $3,000 she says he still owes her, which he conveniently did not mention anywhere in his demand letter. That number can and should factor into any settlement conversation. So where does this leave her? She is doing the right thing. She said she planned to consult a lawyer, and that is absolutely the correct first move. Not because she is necessarily in serious legal jeopardy, but because she needs to understand her position clearly before she responds to anything, or fails to respond when she should. Here is what anyone in a similar situation needs to understand. A demand letter is not a lawsuit. Receiving a letter with legal language, a deadline, and a threat to file does not mean you are being sued. It does not mean you need to panic. What it does mean is that you need to take the situation seriously and get informed quickly. Do not respond to the letter yourself without legal guidance. Anything you say in writing can potentially be used against you if this does escalate to actual legal proceedings. Get a consultation with a family law attorney in your state, specifically someone who understands cohabitation law or property disputes. Many offer free or low-cost initial consultations. Start gathering your documentation now. Bank records, Venmo transaction histories, mortgage statements, your original purchase documents, any records showing the down payment came solely from you. The more clearly you can demonstrate the financial history of the relationship, the better positioned you are. If he does file, do not ignore it. Ignoring a legal filing is one of the worst things you can do. Default judgments are real, and they can be surprisingly hard to undo. Consider whether settlement makes sense. This is not the same as admitting he has a valid claim. Sometimes a small settlement is cheaper and less emotionally costly than fighting something through the courts, even when you're in the right. A lawyer can help you think through that calculus honestly and document the money he owes you. If he is going to make claims against her, she should be prepared to bring counterclaims for the debt he already has to her. Courts tend to look at the full picture. Now let's zoom out for a moment, because this story is a warning for a much broader audience. If you live with a long-term partner and you are not married, you may be more legally exposed than you think, especially if you live in a state that recognizes some form of common law partnership or cohabitation rights. Washington is not alone in this. Several states have doctrines or statutes that can affect how property is treated when an unmarried couple splits. If you own property, pay attention to whose name is on the deed and mortgage and what contributions your partner is making. If you are supporting a partner financially, think carefully about how those contributions are structured and documented. Are they gifts, loans, shared investments? The answer matters enormously if things go wrong. Cohabitation agreements, essentially prenuptial agreements for unmarried couples, exist for exactly this reason. They are not romantic. But neither is a $30,000 demand letter arriving 7 months after your engagement ends. Love is real, so is the law. And the law does not care about your intentions when the paperwork tells a different story. If something like this has happened to you, a demand letter from an ex, a property dispute with a former partner, a legal threat that came out of nowhere, the first thing you need to do is talk to a licensed attorney in your state. Not Reddit, not an AI chatbot. a real lawyer who knows your jurisdiction and can give you advice that actually applies to your situation. And if you found this video useful, if it opened your eyes to something you didn't know about cohabitation law or legal rights in relationships, please consider subscribing. We cover real legal situations that affect real people, the kind of stories that never make the news, but could absolutely happen to someone you know. Hit the notification bell so you don't miss what's coming next. This community is growing fast, and we're just getting started.